Good morning. It's a real honor to be on this panel among some of my personal heroes, and it's a real honor to speak to you today. Two recent events should be sobering for those of us who are committed to the founder's vision of federalism, or with deference to Professor Gerken, federalisms. The first was the Supreme Court's decision to uphold most of the Affordable Care Act. The second, of course, is the outcome of the recent election. Both demonstrate the basic failure of the strategy of trying to restore constitutional limits by concentrating exclusively on federal elections and Supreme Court appointments. The fact is that no Congress or president is likely to do much to restore constitutional limits on federal power, and any efforts of the Supreme Court will be marginal at best. I'd like to talk to you today about a better way of restoring federalism, one that more and more people are discussing at the state level, but really hasn't made its way back yet into the federal consciousness or the national consciousness. This is the ability of states, and particularly state legislatures, to amend the Constitution to rein in a runaway central government. Think back for a moment to the debates over the ratification of the Constitution during the period 1787 to 1790. Those who opposed the Constitution had a range of arguments, but two of those arguments were at the heart of their case. The first was that the Constitution granted too much power to the federal government, and that could lead to abuse. The second argument was more subtle, but ultimately it was more prescient. It was that even if the Constitution, when honestly, fairly, objectively read, did not give the federal government too much power, nevertheless, ambitious and clever people would twist its language to justify the central government seizing enormous power, even if that contradicted the understanding of those who wrote and ratified the instrument. To these arguments, the advocates of the Constitution responded in four ways. First, they emphasized the limited scope of the authority given the federal government. An example is Madison's famous statement that, quote, "the powers delegated by the proposed Constitution to the federal government are few and defined." This was not just campaign rhetoric, because when you examine the Constitution's power grants against the background of 18th century usage and 18th century jurisprudence, you can see that for the most part they were fairly well defined. The phrase regulate commerce, for example, was understood to mean governing activities such as mercantile trade, navigation, cargo insurance, and imposing certain tariffs. But as Randy Barnett, I, and others have documented, did not include such activities as manufacturing, most insurance policies, or healthcare. Second, advocates of the Constitution listed explicitly activities the federal government could not regulate and that would remain within the exclusive jurisdiction of the states. These included local businesses, agriculture and other forms of land use, real estate titles and inheritance, local government, tort law and other aspects of civil justice among people in the same state, criminal law, religion, education, and social services. The Constitution's advocates sold the document to the ratifying public precisely by representing that such activities were outside the federal sphere. Now, let's make one thing clear. Everyone understood that even then there were close interrelationships between these activities reserved to the states and the activities subject to federal regulation. But for overriding and very good reasons, certain matters were left out of federal jurisdiction. The third thing the Constitution's advocates did was, after some hesitation, they promised a Bill of Rights. And the fourth, and the one most germane here, is they emphasized that Article 5 gave the states substantially unilateral power to adopt amendments, which the states could do if the federal government proved oppressive. In other words, the founders saw the amendment procedure as more than a way of responding to changed circumstances. They saw it as a tool for curbing excesses and abuses. During the ratification process, many of the Constitution's advocates pointed out that the states could not only ratify proposed amendments, but that acting through their instrumentality, something that the Constitution calls a convention for proposing amendments, they enjoyed concurrent power with Congress to propose changes in the instruments. That is why Alexander Hamilton said that if the states were determined to insert a corrective amendment into the Constitution, then, quote, that amendment must infallibly take place. Over the last 50 years, state lawmakers have largely overlooked their amendment power because of widespread misunderstanding about this convention for proposing amendments. It is commonly and inaccurately labeled a constitutional convention, and it is assumed to be inherently uncontrollable. Many seem to think it is independent of the state governments, that, for example, Congress can designate how delegates are chosen or how they're allotted. Such misconceptions are the product of ignorance of the relevant history and law. These misconceptions also, unfortunately, are promulgated by groups who are opposed to any amendments. In fact, the Convention for Proposing Amendments is nothing but a diplomatic gathering of the states, to which each state sends a delegation, called a committee, and in which each state stands in a position of sovereign equality. The convention's agenda and its deliberations are subject to the limits imposed by the state legislatures. This is clear from 18th century convention practice, from the record of the framing, from the debates over the Constitution's ratification, and from subsequent history and some subsequent case law. The founding generation had had extensive experience with interstate conventions. The convention that wrote the Constitution was only the latest in at least 18 gatherings among the states that occurred within the lifetime of Benjamin Franklin alone. Leading founders had attended many of these gatherings, and convention's procedures and protocols were well understood. We can recover them today in the convention journals, calls, and other records. When you examine these procedures and protocols, you understand why so many founders affirmed that the states could have any amendments they wanted. In an interstate convention, like the Constitution's Convention for Proposing Amendments, the states run the show. Congress has almost nothing to say about it beyond fixing the time and place in the call and identifying the subject matter specified by the states in their applications. Each state legislature fixes the number of delegates. Actually, the delegates are called commissioners from that state, and determines how the commissioners are selected. The state legislature or its designee grants and defines their authority, instructs them, and may recall them. Once gathered together, the convention adopts its own rules, elects its own officers, and commences the work assigned to it. On the floor of the convention, each state has one vote. The convention decides whether to propose one or more amendments, and if it decides to do so, it drafts them. The proposals are ratified or rejected in the same manner as congressional proposals are. On several occasions before this learning escaped us, state legislatures flexed their Article 5 muscles by applying in a concerted manner for a convention for proposing amendments. At the turn of the last century, for example, the states forced the United States Senate to agree to the 17th Amendment, direct election of senators, when 31 of the necessary 32 applied for a convention limited to proposing a direct election amendment. If recent history tells us anything, it is that we are not going to restore federalism, or for that matter, federalisms, merely by choosing presidents, members of Congress, or Supreme Court justices. The state legislatures will have to do the job. And as James Madison pointed out late in his life, Their ultimate constitutional tool for doing so is the procedure of Article 5. Thank you.
And then we also have a proposal from Rob Natelson to, never mind the doctrinal tinkering, let's blow the thing up, basically, and the states should simply invoke their constitutional authority under Article 5. I told you he was a political provocateur, and go that route. So I think that is sort of a summary of the three themes that we have going on here, and with that, I assume that, Randy, you probably want to respond to what Neil said, and perhaps some of these other ideas as well.
Thank you, Judge Sykes. Yes, I want to respond to what Neil said, but before I do, I first want to, in case it gets lost in the shuffle, I want to express my agreement with what Rob said about Article 5 conventions. I agree with everything that he said about Article 5 conventions. It is a lost knowledge, which no one has done more than Rob has in restoring our understanding of, or beginning to restore our understanding of, and it's a very important structural constraint on federal power that has been neglected. We have to look to the Constitution for the structural constraints that are there. This one was there. It was put in there for a reason. It was put in there by the founders, and it should not be forgotten because of some misunderstanding about what a convention for purposes of proposing amendments is really supposed to be, which is really what has happened for, somewhat political reasons. So I just want to...
But also troubling to me is Randy's suggestion that part of the original plan was that judges are going to enforce the federalism rules and indeed all other rules against the political branches of government. My copy of the Constitution does not have a judicial review clause in it at all. It's just not there. If you remember in Marbury against Madison, judicial review is teased out of the structure of the Constitution, out of the fact that the Constitution is, in some respects, it's got some real legal rules in it, and then it's got some structural organizational rules about how everybody else is going to behave. And the Supreme Court said in McCulloch that when the Constitution's got real legal rules in it, they're superior to what's been done by the agents under it. I certainly agree with Randy that the principals are the people and the government is agent. That's the original understanding, I think, and where we get judicial review from is this structural argument in Marbury. And now, it seems to me, important to ask, what is the original understanding of judicial review on questions of federalism?
Okay, well, first on the issue of judicial review and its legitimacy. Judicial review did not originate in Marbury versus Madison, nor is it rooted purely in the structure of the Constitution. It was well understood as an institution when the Constitution was adopted. It is mentioned in Federalist number 78 by Hamilton that the courts would void laws that were unconstitutional. There was extensive discussion on the subject at the Virginia Ratifying Convention, in which anti-federalists said, hey, look, what happens if the federal government exceeds its powers? And the response came back from, among other delegates, John Marshall, that then the courts will strike down the laws that exceed the Constitution. And the response of the anti-federalists, like Patrick Henry, is, let's hope so. We recognize that the Virginia courts have struck down unconstitutional laws. Let's hope that the federal courts do so also. Dean Traynor of Fordham Law School in 2005 in an article in Stanford Law Review identified something like 32 cases before Marbury versus Madison in federal and state courts, including a fair number of them before the Constitution was ratified, in which judicial review was acknowledged or applied. It was actually a concept that went back to practice under the colonial charters. Secondly, I would like to take, as a matter of personal privilege, defend myself against the charge of being a provocateur. I do not want to blow up the system. If you look at the size of the federal debt, Congress is doing a pretty good job of it itself. I would also like to defend myself against the charge of being a visionary. It would certainly be visionary to claim that the states, through the Article 5 amendment process, are going to return us to the pristine days of 1787. I don't think I would want them to do so. However, the fact is that at one time, not too long ago, we already had 32 of 34 states, one shy of those necessary to apply for a convention for proposing a balanced budget amendment. Now that crested for a number of reasons, including charges that the proposed convention would be a constitutional convention, based, as I mentioned earlier, on ignorance of the historical record and of the law. But we still have something like 15 applications out there right now, which means we need 19 more. This is far more, I would say, than the advocates of repealing Citizens United have. And in fact, we just got another one. New Hampshire just applied for one. So I would, you know, at the risk of being a starry-eyed romantic, I would say probably the odds are about even that in the next 10 years we will get a convention to deal with some discrete federal issue, probably fiscal. Professor Gerken's contribution in the area of federalism, in part, has been pointing out that there are different kinds of federalism. There's what she calls sovereignty federalism, which is sort of divide up the turf federalism, which is what we usually think of as being it. There's cooperative federalism, there's the servant role. What's interesting here is that all the kinds of federalism that she identifies actually are in the Constitution. When the state courts apply a federal law, they engage in the servant role of federalism. When the states trigger Article 5, for example, they engage in process federalism. There's also a significant area of sovereignty federalism, and Professor Gerken has pointed out that sometimes sovereignty federalism can be a valuable bargaining chip when you're negotiating with the feds over some issue or other. Where I think we would disagree, however, is that where all types of federalism occur in the Constitution, I think we would disagree with where the balance is. I would argue that there's a lot more sovereignty federalism in the Constitution than many progressives would acknowledge.
Would anyone like to comment on that as a broader issue, prosecutorial discretion and where it fits into this discussion of federalism?
Quick thing.
This is actually a very interesting topic in Colorado and in some other states like Montana, which have legalized medical marijuana. We've gotten conflicting messages from the Obama administration as to what extent they're going to be enforcing the laws against medical marijuana, which they can, of course, under Gonzalez versus Raich, ably argued by Randy Barnett, which in fact they can.
More ably argued by Paul Clement.
Generally, the feds have been pretty circumspect, I guess, because it seems like we've got a medical marijuana dispensary on every corner now. The patience of the feds is going to be tested even more because we just completely legalized marijuana, and this is going to be an interesting. It's going to be an interesting ride, I think. You mentioned the Stevens Hopkins Center. That's the name of it.
Yeah.
One of our lesser-known founders. Remember in my principal talk, I mentioned that there had been all of these other interstate conventions held before the Constitutional Convention. Stephen Hopkins attended a number of them, and in fact, he chaired 3 of them. The question is to the level of how unprecedented this was. You have to look at 2 different issues. First, is this truly a tax? And secondly, if it is a tax, is it a direct or an indirect tax? Again, from an originalist standpoint, the founders would have said, if the measure is imposed primarily to raise revenue, it's a tax, even though it may have incidental behavioral consequences and may even be imposed with knowledge of and desire to have those incidental behavioral consequences. On the other hand, if its primary purpose is to influence behavior, it is not a tax, it's a regulation of commerce, even if it may incidentally raise a little bit of revenue. Using that test, this was a regulation of commerce, not a tax. Now, it is also true that subsequent Supreme Court case law has muddied that distinction, which was a very important one to the founding generation. It's part of what the revolution was fought over. So you can make the argument, though, based on the intervening case law, that the tax finding was not unprecedented. Then you have the direct versus indirect, and this, I think, is the weakest part of Chief Justice Roberts' opinion. Basically, The difference between a direct and an indirect tax is actually a lot easier to recover than a lot of writers assume. Basically, a direct tax is one that is imposed upon you for just existing or for earning a living. As Chief Justice Roberts pointed out, there are taxes that are imposed for just existing. Capitations are, and he gives that an example. Well, yeah, but the capitation is a direct tax. It's not an indirect tax. The income tax is a direct tax, but it's been preserved from the need for apportionment by the 16th Amendment. So I thought that part of the opinion was quite weak, and I think from a standpoint at least of an originalist viewpoint, if it is a tax, it's clearly a direct tax.